And now the race between Ricky McKoy-Mitchell and Valerie Johnson Zachary. So first we're going to begin with Judge McKoy-Mitchell. The question for her is this. You have served as a district court judge since 1998 and are currently the longest-serving district court judge in Mecklenburg County. The members of the NCADA, however, predominantly handle matters pending in Superior Court, Business Court, or the Industrial Commission. Can you tell us how your experiences at the trial court level have helped prepare you to rule on appeals our membership may be handling before the Court of Appeals? Judge McKoy-Mitchell.
Good afternoon, everyone. I'm Judge Ricky McKoy-Mitchell, and I'm a candidate for the North Carolina Court of Appeals, Seat 4. Thank you, North Carolina Association of Defense Attorneys, for having us here this afternoon and being able to have a few moments to talk with you about why it is important that I gain your support for that seat. Giving you a little bit of my background first and put it in context. I'm from Eastern North Carolina, so I was born in Harnett County. There, being reared and understanding the importance of having a hard work ethic, which I've carried with me all of my life. Went to Chapel Hill both for the undergraduate and law school, where I received a academic scholarship there. After coming out of Carolina, actually having legal experience in every part of our state, whether that was the eastern area, middle area, western area, where I primarily have been most of my legal experience. In Mecklenburg County and in other parts of the state, I've had the opportunity to work 14 years before actually coming onto the bench. So that was 14 years of very varied experience, whether that might have been unemployment law, employment law, community economic development, whether that was with the Office of Hearings and Appeals for the Social Security Administration, writing decisions, researching complex issues about our disability area of the law, or whether that might have been working with Title VII or prosecuting cases in the district attorney's office anywhere from minor traffic offenses to murder cases. So having had all of that breadth of experience even before going on the bench, 14 years of that. Then when going onto the bench, and yes, I am the longest serving district court judge in Mecklenburg County for 18 years. And there's not been a question about whether or not I've actually been in each one of our courts. I have served each and every facet of district court. What becomes very interesting about that is that most times when people think about district court, because you're asking the question about practicing in business court or superior court, or whether that may be the industrial commission, as much of that, whether that was from my experience before or currently being on the district court bench, have been able to have similar experiences and been able to sit in the seat of a trial court judge, and then on the Court of Appeals being able to look back over my shoulder and know what it is that is expected to be happening at the district court or a trial court level. When people hear district court, because it really is where most people have had any involvement in our court system, they think typically of it being our traffic cases. So why would I be interested, and why would you have me on the Court of Appeals with a traffic court case? Well, let me tell you, that's not what all district court is. What you don't hear is my presiding in our domestic court, where I presided over multi-million-dollar cases with very complex equitable distribution issues there. It doesn't tell you about my being in civil court, where I presided over both bench and jury trials. It doesn't tell you about each and every area of the domestic case or each and every area of civil or criminal or domestic violence or child support or involuntary commitments, all of those issues which go, including areas very similar to your own, where they go to the Court of Appeals, where you want a judge who is fair, who is experienced, who is committed and respected, because you see from my own reputation that I've built in the district court, I've been selected to be a faculty member with the National Council of Juvenile and Family Court Judges because they understand what I can bring to other judges, teaching judges at the local, state, federal court level, and even international level. And that also I've been highly rated by judges, district and superior court, by attorneys who practice in multiple areas, as highly rated for legal ability, professionalism, fairness, integrity. And just like you say in your mission statement, you want a balanced and fair judiciary. Well, then you want Judge McKoy-Mitchell on the Court of Appeals. So I seek your endorsement and your support. Thank you very much.
And now current Court of Appeals Judge Valerie Zachary, and here was the question that was presented to Judge Zachary. We now know, after both legislative action and appellate decisions, that North Carolina has become a Daubert state in regards to the admissibility of expert testimony. Please explain your view of how the Daubert standard either has been applied or should be applied at the trial court level, and indicate the facts that you might generally look for in determining whether the trial court in an appeal has abused its discretion regarding the admissibility of such expert testimony. Judge Zachary.
Thank you, and thank you all for having us here today. I'm Valerie Zachary. I'm a judge on the North Carolina Court of Appeals. I am from Yadkin County, which is in the western part of the state, on the west side of Winston-Salem on the way to Boone. I'm in John Willardson country, and I would hope that you would not hold that against me. I attended Michigan State University, where I received my degree in multidisciplinary program, French economics and political science with honors. I then attended Harvard Law School, where I graduated cum laude. While I was at Harvard, I was invited to serve as a moot court judge for the qualifying round of the Ames Moot Court competition on the basis of my writing and analytical skills. I was also invited to accept employment with Professor Lawrence Tribe, assisting in the revision of his treatise on American constitutional law, which I enjoyed very much. I then wanted to return to North Carolina, so I accepted a position on the litigation team at Kendi, Covington, Lobdell, and Hickman in Charlotte, which is now K&L Gates. I was traumatized by Jim Cooney there, still haven't gotten over it, but I hope to soon. I then met my husband. He's from Yadkin County also, moved back to Yadkin County and was in general practice there for 26 years. I've handled all types of cases there in Yadkin County, from receiverships to special needs trusts, elder law issues, ERISA issues, Aetna defense work, adoptions, you name it, we did it. The last case that I had before I joined the Court of Appeals, I had someone come in that wanted to have her brother declared dead. And I don't know how many of you have ever had a case like that. I had always heard that they had to be missing for 7 years, and that's not true. You can get it done much quicker than that. So I've warned my husband that it wouldn't take that long. Yeah. But Chief Judge Mickye calls the Court of Appeals the General Practice Court of Appeals, and I think that she's correct. I think that being in general practice has been a tremendous advantage to me on the court. I also think it gives me a unique perspective, which is a value to the court as well. I feel like I've earned the respect of my colleagues, and my opinions are available for your review at nccourts.org. I hope that you will take the time to take a look at a couple of them and see, what your opinion is. I certainly would appreciate your support. Now, regarding the Daubert question, in 1923, the U.S. Supreme Court issued its opinion in the well-known case of Fry and ruled that expert witness testimony could not be admitted into evidence unless it was generally accepted in the field. Some 70 years later, in 1993, Fry was superseded by Daubert, which really had a much stricter standard. In 2011, the General Assembly amended Rule 702, I think to make it clear that North Carolina should be a Daubert state. Recently, The North Carolina Supreme Court affirmed the Court of Appeals holding in State versus McGrady and has specifically stated and declared that North Carolina is now a Daubert state, which is a much more rigorous standard than we had in Fry. I don't know how many of you have filed your Daubert motions yet. I'm expecting to see some come up to the Court of Appeals. But I think as a preliminary matter, it's important to recognize that the nature of expert testimony has changed since 1923. Things are much more complicated, much more technological, much more scientific, and juries are very prone, I think most of us will agree, to defer to the opinions of experts. And so then you end up with some serious mistakes based on ostensibly scientific methods, such as forensic odontology, bullet lead comparison, bullet markings analysis, microscopic hair analysis, issues like that that ultimately turned out to be unreliable and biased. With Daubert and McGrady, we now have the judge in a more of an expanded gatekeeper role to be sure that the opinion that the jury hears deserves the respect that the jury is probably going to give it. I think most significant with Daubert is the issue of reliability. The judge needs to be sure that there are sufficient facts and data, that there are reliable principles and methods at use, and that the methods are applied reliably. At the appellate level, I don't think there's any question but that the findings of the trial court are binding unless there's no evidence. It's reversible. A reversible abuse of discretion is only if it's manifestly unsupported by reason, which is a hard standard to meet, and that's not likely to happen. I would look as an appellate court judge, of course, to see if there was evidence supporting the findings. I think it's also important to look to see if there's peer review, if there are independent studies, if there's duplication of results, if the expert exceeded the scope of the expert's expertise, among other issues. I thank you for having us here today. I appreciate you taking the time to listen to us and get more informed about the judicial candidates, and I hope I can gain your support. Thank you.